So hello and welcome to this hour-long CYCJ webinar on balancing the rights of children who harm and those who are harmed. My name is Lauren Emerson. I'm one of the practice development advisors here at CYCJ, and I will shortly be introducing our guest speaker, Judy Warburton. However, I wanted to cover just a couple of practical aspects of the webinar first. So firstly, the webinar will be recorded. You will have been aware as you joined that your camera and mic have been switched off for this webinar, and only the speakers and organisers of the event will have their cameras on and their faces in the picture and in the recording. We're going to hear from Judy in a moment for approximately 40 minutes of input, and then we will open up the floor to questions, which we will do our best to answer. This webinar has attracted a huge amount of attendees, which we're delighted about, but it also means that we may not manage to get round all the questions. So if your question remains unanswered at the end, we will take a note of all of those and do our best to follow up and answer any unanswered questions towards the end. So the other thing of note is, because of the volume of attendees this afternoon, we're going to use the Q&A function in Teams, which is hopefully familiar to you, but it's up in the top ribbon towards the left-hand side, and you will be able to put your questions in there throughout Judy's presentation as well as at the end. So please feel free to do that. I believe that the phenomenal response that we've had to this webinar really highlights what an important issue Judy will be talking about today, both in terms of those invested in implementing the Children, Care and Justice Act, but also the importance of supporting and looking after the needs of children who cause harm, as well as those who experience harm, and very much recognising that at times that those are the same children. So I'm going to introduce Judy. Judy Warburton is a research officer at the Scottish Children's Reporters Administration. She has been researching in the field of children's rights and youth justice for over 10 years now, and has a particular interest in the meaningful participation for children of all ages in decision-making about their lives. So very relevant to the work that Judy will be talking about today. This research has been looking at victim information and support to support the implementation of the 2024 Children and Justice Act. We'll not be sharing Judy's slides immediately because we'll be waiting until the accompanying report is published, which will be sometime before the 26th of March, but we will be sharing the slides and they are very rich and engaging slides, so you'll be delighted to know that you are going to get to see those and get a copy once that report is published. So without further ado, I'm going to hand over to Judy now for her presentation. Judy.
Thank you. I'll just share my screen. Is that good? Yep. Okay.
Yeah.
So yeah, hi. Thank you for coming, everybody. It's been a really interesting project to work on. So I hope you find the presentation useful. As Lauren said, my name is Judy Warburton. I'm a SCRA research officer, and I can be reached on the email research@scra.gov.uk. So I will make a start. So I'm going to start by giving you an overview of the research before going on to look at how the SCRA Victim Information Service is used, the impact of harm on victims, systems-based trauma, victims' understanding of the children's hearing system, interactions with our Victim Information Service, wider experience of support, young people's views, a quick look at restorative justice, and finishing with conclusions on what information should be shared. So an overview of the research, so what we did basically. So we analysed more than 8,500 victim records from the 1st of January to the 31st of June, sorry, the 1st of January 21 to the 30th of June 24, highlighting the nature of harms caused to victims, the age of the victims, and which harms were most likely to lead to victims seeking information. When I talk about victims' records, that's the SCRA Victim Information Service records. We did a case file analysis of 200 victims' records, which were randomly selected out of those 8,500. We did in-depth qualitative interviews with one child victim and 5 parents of children who had been sexually or physically harmed. And we did in-depth interviews and group discussions with 8 young people who had caused harm and 37 young people who had both experienced and caused harm. It's fair to say we have significant difficulties in recruiting victims, despite the involving the several victim support agencies. And we would obviously have liked to interview more victims, but all the victims that we spoke to were extraordinarily open in sharing their experiences with us, giving us a great depth of data. And the similarity in their experience and needs allowed us to triangulate the data and draw conclusions. So, looking at our data, so these are the harms that we recorded in our systems, analysed by the very broad police crime classifications, but it gives us some idea of the sorts of harms that we are dealing with. So clearly, the majority were non-sexual crimes of violence, followed by crimes against society, but not an insignificant number of them were offences or harms of a more serious nature, and it's those harms that the interviews really are dealing with. So we looked at who were the victims in the VIS data set, and found that, well, just some highlights were that there were more male victims than female, but women were more likely to be recorded as victims of sexual harm, and that the average age of victims recorded was 14, with 1 in 2 of those harmed being aged 10 to 18. So the majority of victims of children who are referred to the Children's Hearing System are children themselves. We found that children were more likely than adults to be recorded as victims of non-sexual crimes of violence. And then you've got the 58% versus 42% and a median age of 16. And that children were more likely than adults to have been victims of sexual crimes or sexual harms by children referred to the reporter, and that you can see is quite a substantial difference. We found that 55% of recorded victims lived in the most deprived communities in Scotland. In the subsample of cases, we were able to discover that 73% of victims have been harmed by one child only, and that's out of a range of 1 to 6. We found that 46% of victims knew the child that had caused them harm, and that in 66% of cases where the child who harmed was known, they were a peer, a classmate, or a partner of the child who was harmed. So we then went on to look at who were more likely to seek information from the Victim Information Service. So just I guess a bit of background on how the SCRA's Victim Information Service works. When a child is referred to the Children's Hearing or Children's Reporter on an offence ground, we, SCRA Victim Information Service, writes to either the child or either the victim, or if they're a child under 12, their parent, and if they're under 16, to both child and parent, telling them that they can opt in to receive information from us on the outcomes for that child, and also giving them information on what the Children's Hearing System does, and signposting them to victim support agencies, so that it's then up to the victim to get back in touch with SCRA and say, yes, we would like to receive that information. So it's very much an opt-in system, not an opt-out system. And that comes from research we did very, very early on that told us that's what victims were looking for. So we found that women are more likely to opt in to receive information than men. And we found that opt-in rates were higher for sexual offences, 25% versus 11 to 13 for other offences. And those two things are obviously correlated. It may explain why women are more likely to opt in than men, because we saw earlier that women are more likely to be victims of these harms. Our Victim Information Service is more likely to get requests for information when the victim is a child. And again, it's possible that that's because it's the parent who's opting in to get that information. Opt-ins are more likely to come from those living in affluent communities, and also that knowing the person who caused harm or being a repeat victim both increase the opt-in rate. So looking, we looked at opt-in rates by offence record in more detail. And although the overall opt-in rate for receiving information from VIS is less than 9%, if we break down the opt-in rates by types of harm within the police crime classifications, we can see that all of these harms are significantly higher than the 9%. So stalking's at 40%, sexual harms over 30, and all the way down. And that suggests that victims are more likely to seek information when the harm that they've experienced leaves them feeling vulnerable and where there are going to be ongoing safety concerns. Okay, so that's a quick look at the data. Obviously, it's in much more depth in the report. So moving on to look at what we found from talking to victims. So it might be worth saying here that it was clear that the trauma of what they'd been going through at the time appears to have left some of the victims and their parents with confusion around some of the detail about what happened to them. And this was possibly compounded by the lack of information about what was happening to them and what was likely to happen to them. So we found significant mental health impacts of harm demonstrated throughout. So one parent says, unfortunately, now my son is even worse. He's got severe PTSD. He's got depression. He's not leaving the house. He's not going to school. He's not a normal little boy anymore. And somebody has done that to him, and that's really difficult. And another mother saying, my daughter was suicidal. She was cutting herself. We found that the parental load of supporting the child who had been harmed adversely affected the physical and mental health of parents, and descriptors of survivors' guilt among parents, and also not being able to not being able to support the child, feeling, so the mother said, I felt like the worst mother on the planet. I could have cried rivers. I let him out that day. I could beat myself up. Also, there was an impact on the quality of family life due to the withdrawal and changes in the child who was harmed, as well as the trauma of the rest of the family. So it had a huge impact on mine and my husband's relationship with our daughter. She really struggles with her relationship with her sister now. And before the attack, she was a bubbly, popular, happy wee girl. She has had tons of friends, and since the attack, that's all changed. And also, the re-traumatization was highlighted for the child and family through exposure to the child who caused harm in school and the community. So one a child said, I left school. You think of it 24/7 when you're there. I walk past him every day. There's just so much stuff going on, so I had to leave for my mental health. I couldn't stay. I couldn't do another year in school if he was going to be there. So significant impact of harm on victims, but also system-based trauma. So whilst individuals at all of the youth justice agencies, the police, social work, procurator, fiscal and SCRA, who treated victims and their families with compassion and kindness and took time to explain what was going on, were distinctly remembered and appreciated. The interviews largely highlight the traumatic nature of engagement with the youth justice system. Sorry. So just some examples of this. Some felt that the seriousness of the harm caused to them was dismissed by police and they hadn't felt believed. So the quote, we reported it to the police immediately, but they didn't take it seriously. They didn't take it as the crime that it was. It had a lot to do, we had to do a lot of fighting to get the charges as attempted murder because they were saying it was sexual assault. They said the intent was not there. My argument was, if you put your hands around somebody's throat and they're conscious, there's intent there. He might not have left the house that day to attempt to murder, but that's what it was. So that also speaks to the next point, which was there was a clear sort of social versus legal definitions of harm and parental misunderstanding of those legal definitions. So here the parent, as you saw, the parent was convinced it was attempted murder, but because there was no intent, it couldn't be charged as such. And there was another case of that where one of the victims had been a victim of rape by a child who was under the age of criminal responsibility, and therefore it was not considered to be rape, and the parent couldn't understand that at all. You can perhaps understand that. So the stress was made worse by off-the-cuff remarks by those in positions of authority about what would have happened if the child was an adult. And 2 or 3 victims spoke of this. So police saying things like, our hands are tied. If it was an adult, they'd be in the cells right now, they'd be in the jail. And also referring to children as frequent flyers. And that they were known to the police, that they were known to the system, and all of these things the parents highlighted as making things worse, even though the people who were saying them were probably trying to make it better. The victims' parents also reported traumatic and confusing experiences of disclosing harm, of participating in investigations and giving evidence in court. One parent was describing her 10-year-old's experience of being at a lineup, an identity parade. And as you see, he went through the whole thing again, and he had to face the boy again that was glaring at him through the screen. And then he had to say, and you think, come on, he's 10. I was sobbing my heart out for him. He was sobbing his heart out. And then he just ran out of the room. And when it comes to reporting it to the police, they have to be like an adult. They're expected to sit in a room with strangers. They're expected to tolerate stress, the stress. It's worth saying that none of these children had access to bouncers. All of the harms were committed 2 or 3 years ago, or suffered 2 or 3 years ago, and yeah, none of the young people involved here had access to bouncers. There were also instances of experiences in court. I think come on to those later that were less than child friendly. There was particular issues around cases that were jointly reported to the Procurator Fiscal and the Children's Reporter. So these parents had effectively experience of both sides of the youth justice system. And so this slide in particular applies to their experience of the being reported to the PF. So there were problems understanding the legal language used. So the lead detective explained to me, you're in this land of legal jargon, and we never have never had any experience of that. We understood the first attack was jointly reported. So just expressing the difficulties of being involved in legal jargon. Expressing not understanding why the decision had been made not to prosecute, not really feeling that had been explained at all. So we were never told what the decision had been made. All we were ever told was that a decision had been made by Crown Counsel at Crown Office. We don't know what that was, and it was just decided it would be better dealt with by the Children's Reporter. We never found out why they'd sent it to the Children's Reporter. Nobody told us. We had to find all that out ourselves. Also, long periods of time of non-communication. The process of the PF making a decision, of the Crown Counsel making a decision, we know can be protracted, and parents felt that they weren't being kept up to date during that period. There was nothing to tell them, so they weren't being told anything. I don't think was the idea. Examples of the decision to refer to the SCRA just not being communicated at all, and finding out not from the Fiscal's office, but from the children's hearing from SCRA, from getting the letter from victim information, that a decision had been made to pass it to the children's hearing system. Victims' names being incorrectly spelt in letters, and that comes up later with the Victim Information Service as well. And parents were really incensed that the system couldn't get their children's names right. It made them feel very unsupported, uncared for, as though they were irrelevant. And I mean, both systems we know are reliant on the information that they're passed, but it was something that came up again and again and again. UNCRC focused language was considered to be dismissive of both the harms caused under the rights of the child who'd harmed. So the language was something that was really, really annoyed us. The letter the Lord Advocate sent to us said that the best interest of the accuser and the child victims were both taken into account. My child was so angry when we told him, when he saw that, he said, nobody's asked me what my best interests are. And just the point that a lack of information resulted in parents seeking information unofficially. So asking around the community, asking friends, looking. So eventually I started going through people that we knew through mutual friends, because the girl lived locally. I was able to ascertain from them that a report did go to the children's reporter, but from what she understood, nothing came from it. So having to go out and get hearsay, really, and leading to misinformation and more distress. So moving on to understandings of the children's hearing system. So once the children had been referred, the case had been given to the children's hearing system, to the children's reporter, we found that those with prior understanding and knowledge of the children's hearing system meant that they had more realistic expectations of what was going to happen. So they talked about expecting there to be no conviction, expecting the child to be given learning and teaching, to live with mum in the community, to be placed into care. They had some idea of what they were expecting from. So in this case, the mother said she was lucky she had a friend whose daughter worked for the children's reporter. She was like a source of information, that she knew what would happen and what was likely to be the outcome. Whereas those with no prior understanding had no understanding of what being referred to the children's reporter meant. They had no idea of what the possible outcomes might be and what it meant for the child who harmed them. So there was no information. I had to Google everything to do with the children's hearing system. I Googled everything. And it reflects a wider understanding of the youth justice system. And that we found both amongst the victims and their families that we spoke to, but also amongst the young people that we spoke to. Just a lack of understanding of the difference between court and the children's hearing system, a lack of what children's hearing system meant, just a lack of any kind of path of what was likely to happen. They also found just like with the referrals to the Procurator Fiscal, they found legal language of the children's hearing system difficult to understand. We didn't even know what it means. No compulsory measures are required. It's like there's no compulsory, like he's not going into secure care or anything like that, but it doesn't say anything about anything else. Whether he needs to go to classes, he needs to be taught, he needs to get a row, did anybody speak to him? You know, was he told it was a bad thing? There's just nothing in there about that. So we talked to victims about what their not understanding, not just of the process of the children's hearing system was, but of the process of their understanding of its approach, what the children's hearing system was trying to do. And there definitely was an understanding amongst victims that the purpose was to rehabilitate and not criminalise. So at the end of the day, I've got kids, I know that they can be wee shites, that they can make mistakes and all of the rest of it. And I do agree with the whole trying to rehabilitate them. I don't disagree with the whole process. So definitely an understanding of what was trying to happen. There was very much a hearts versus a head versus hearts narrative in the whole conversations with the victims, especially with the parents. The child who raped my son, is a victim. My question would be, where did he learn that? And so an understanding of the children who cause harm are victims too. But also, we get that nobody wants to unduly criminalize children. We absolutely get that. But we get we get that Borstal or whatever they're called now is a pretty awful place. Nobody wants somebody going into something like that because they've vandalised a wheelie bin or graffitied somebody's shop window. But when it's a serious crime, we just can't understand how the children's reporter could be an effective deterrent. So a real sort of, we understand, but this was something different. And a feeling that that they understood the system, they believed in this system, but that was before this happened to them. So one mother said, before this happened, I would have believed that children shouldn't be in jail, but now she didn't feel that way at all, and yet she did really. That's the whole head and heart thing again. I absolutely understand that prison isn't a place for these young offenders. However, when you've been on the receiving end of a child that's extremely damaged by an offender, it's really difficult to see the two sides of it. You're very much like, rehabilitation is all very well, but you want your child's rapist to be hung. And also, yeah, that some things are just too serious to be dealt with by the children's hearing system. Some more sort of views on child welfare based approach to justice. There was a very sort of complex and nuanced view on what justice means for them. So some were angry and wanted punishment, but their views on what this meant were complicated. So the first big quote, the boys and girls, they get beaten up, they have horrible times as children. So a real understanding that this came from a mother who had worked with young people who had offended in a previous job. But you can see with the right support, with the nurturing, the children fare better. Some of them won't because they're going to have, a lot of these young people will end up in the prison system, but some of them won't because they're going to have a good life, and that's what you want, isn't it? Because but she goes on to say that she's trying to talk about what she feels justice is, and she wants the young people to have a better chance in life. She understands they needed it, but what she's saying is justice for me would be that the child who caused harm never hurts another family or person. But then there's no formal punishment given for what she'd done. She walked away, they walked away. My girl, her entire life was turned upside down. Nothing happened to them. They got away with it. Somebody has to say that the system isn't one size fits all. And we understand what Scotland is trying to do with the children's hearing system. How many times do you flog a dead horse? And the kids out there, they used to brag that to my child at school that nothing will happen to me, that you can grass me up, I don't care because nothing will happen to me. And they just know that there is no deterrent, that surely they can only get so many chances. And this speaks to the idea that there was a feeling that their children who were already in the system didn't see it as a deterrent, weren't facing any consequences, and just went through the hearing system and came back out and continued to behave the way that they had. The big thing here is that there was the lack of information about what happened to children who were referred to the reporter and go through the hearing system, or go through the hearing system. It's fueling the confusion that victims feel and their views on the hearing system. So one would have said maybe a bit more information about what was going to be done, because surely nothing was done. Surely it wasn't just told, right, that sheriff says that you're a rapist, but don't worry, you're 13, you can go home with your mum now. Surely it must have been some sort of follow-up for him for that, some sort. And surely he has had some work done, but there is no mention of anything in here. We're just left to assume that nothing happened. It's just a sentence. We're lucky. We thought that he would get. I thought he would at least get a social worker. So all of these things that are things that we know are likely to be happening with the young person who caused harm. The victims don't know that that's happening and are left with that sort of complete vacuum of simply not knowing. There was one a victim was pleased that they at least got to go to court, and the boy who had raped the young girl, who had been denying it up until that point. It was, although the mother talks about him being found guilty, it was a proof, a hearing proof, and it was found to have been proved, and they felt that at least that that had given them some level of closure, some level of understanding. So just moving on. I mean, there really was this a head versus heart thing. There really was an empathy expressed towards the child who caused the harm. I meant to change that title. So it's supposed to empathy towards the child who caused harm. So there was a recognition of the additional needs of the children who had caused harm. So these are just comments that were made by victims. So her brother had died recently. His mum didn't even come to court with him. He didn't have any friends. So that was a girl talking about the boy who had raped her. So she'd befriended him because he didn't have any friends. The victims reflected on how traumatic the legal journey would have been for the child, so he was not being supported in court. Imagine how difficult it was to hear the sheriff say, "You did this." I can imagine that was awful. Participating in a joint interview due to being a victim of sexual abuse, and individuals in positions of power appearing to have failed children who'd caused harm. But there was real a non-disclosure, a protection, if you like, of the people who had harmed either them or their child. So refusing to tell anybody, so that the young girl who'd been raped, who was at school with the child who'd raped her, refused to tell anybody at school that she'd even been raped because she was afraid of the impact it would have on the boy if everybody found out. And actively pushing back in the community against individuals who asked for the child to be named and shamed on social media, and ensuring that acts of retribution by their own family didn't occur. So one victim talked about having to stop her older son from going out and taking his own retribution on the child who'd harmed. That's just a quote by one of the parents. Okay, so that's kind of looking at the trauma of being a victim. And then move on to look at those who had contact with the SCRA Victim Information Service. And I'm running out of time. I'm really sorry. So 4 distinct cases.
We've got about maybe 5 to 10 more minutes of input, if that's okay, just to allow enough time for folk to
whiz through it. I'll maybe not read through the quotes so much. You can maybe have a look at those while I'm talking. So 4 of the cases had been referred to SCRA. VIS the victim information staff were remembered as empathetic, caring, and having made parents feel listened to. But there was definitely a lack of satisfaction with the written communication. That was the big bugbear. So again, legal language being difficult to understand, language feeling cold and formal. Comments about the black polythene envelope that SCRA's correspondence arrives in being very triggering. Language being dismissive, minimising harm, i.e. referring to the incident in the letters. Language perceived as insensitive. So this idea of, I hope you found this helpful when telling victims that either, as you know, because of the legislation, SCRA can only tell the victims whether or not a hearing is to be held and whether or not the child was subject to compulsory measures. And then at the end of the letter, it says, we hope you find this helpful. And more than one victim found that very insensitive and inflammatory. Again, incorrect spellings of names. And just an unhappiness about the lack of information on what was happening with the child and what support they received to stop them from hurting others. Again, information seen as a barrier to healing. So moving on to access for support. So those who'd been through the courts spoke positively of the support they'd received from reporters and the Procurator Fiscal in terms of producing and delivering evidence. But there was definitely a lack of satisfaction in the availability and timing of supports. Not being, so in that gap between a child being jointly referred and the PF making the decision that the reporter should take the referral. The Victim Information Service, our Victim Information Service, can't contact the child or the victim until it's decided that we will take it. And so that gap before they before they get all the information that the Victim Information Service offers them. A lack of resources, a lack of especially third-party supports. It's a postcode lottery. If they're there, they're there. If they're not, there are age restrictions so that victim support services don't provide support for children under 12. So one mother was told they could support her, but not her child. Huge difficulties accessing CAMHS, having to pay for mental health support privately, having to wait. Inappropriateness of informal counselling support. So there was a school support that just it was too short. But it was 3 sessions by the time there was an introductory session, a middle one that really didn't get into any detail, and an end one that said goodbye and really not very helpful. Supports need to be available at the right time, and parents talked about just having that one person needing somebody there to hold their hand, to talk them through the system, to let them to show them what helps were available when they were ready for it. Schools were left to provide supports in a lot of cases, which put them in a very difficult position because A, a shortage of resources, but B, the child who'd been harmed and the child who were harmed were in the school together. And because the child who caused the harm had not been found to have done so yet, they couldn't sanction them at all. They couldn't restrict their movement. So it had to be the child who'd been harmed who was restricted. So it's a very difficult situation. Perception that the child who harmed got everything. So in this quote here, the child who harmed had a chat every morning to make sure she was ready for school. He was ready for school. You've set everything up, whereas the one who had been harmed got nothing. Parents' was seen as positive by those who knew about it, and also those who had found safe. The Safe Service spoke very highly of the supports they received. This is just a quick case study. So one of the victims was very much supported. It was the rape victim. They were immediately referred to Sanderford. Police encouraged them to contact Children's First. They were offered initial rape counselling and then went to Children's First for delay. They appreciated the reporter's preparation as witness. They had a very positive experience with Children's First. The rape was validated by the sheriff. They considered themselves lucky because they had family and friends who worked in social care and could help them through and understand the referral to SCRA. But even they had had issues. Whilst they got the support that they needed when they needed it, they still had significant reservations about the process of information. They had long waits to get information from the PF. They suffered from the language and the name, and you've seen some of their quotes already. And they found court experience traumatic, and weren't treated in a child-friendly way in any way. I can just quickly talk about young people's views. So they also showed a lack of understanding of the youth justice system, but largely felt, the majority felt that personal identifiable information should be kept private. They expressed a fear of retribution if information was available. They had mixed views on the effect of the age and seriousness of the harm on whether or not that should mean that information was made available. And they also had issues with the language of the hearing system. But as with victims' view on the handling of offences, children's views on how much information is too much information differed. That's the word I'm looking for, depending upon whether they were reflecting on being a victim or the person who caused harm. So that one young person was very clear that he absolutely wanted to know who it was that had caused him harm and what had happened to them, but he wouldn't want them, he wouldn't want those he had harmed to know who he was. Just a quick thought on restorative justice. So none of the victims had been offered restorative justice. In general, support for both victims, in general, it was supported both by victims and by young people. So there was a victim felt that it would have been helpful for her family and for the child who harmed her family to know that the impact that they'd had on their lives. And the victim's parents, who wanted an apology from a parent who'd harmed her daughter, shows that some victims just wanted recognition of the harm. There are poor examples of poor experiences of restorative justice being used in schools and secure units instead of punishment. So you just come and apologise to the person you've hurt and you won't get punished. Excuse me. Young people were unable to understand how it could be helpful to both themselves and to those who harmed. But it was felt that it was important that it was done properly, and that they shouldn't be forced to take part in it. The young people were able to understand, but they were definitely mixed views, with some of them being concerned that they wouldn't be able to control themselves if they met the person who'd harmed them, and others that they would be scared to meet the person that they had harmed. So, and this is my last slide. So I guess in conclusion, the views of the victims and young people of what information should be shared generally reflects the provisions within the CCJA. So definitely privacy for children who cause harm should be maintained, was the view across most of the people we spoke to. More insight needed into interventions used to prevent offending. So more information, victims wanted more information about what types of interventions were used with young people, about what sort of support that they got. Not non-case specific, but more of an education and more of, in their case, sorts of information about what social work can do, what work can be done with children. And information about about work being done locally to address harmful behaviours. So what's being done in my community to address the kids who wander around on the streets and cause harm. Again, non-specific information, but information that will help them to understand what's being done with the child who caused them harm. And victims need and should be entitled to safety information. So the interviews highlighted a range of things that it was felt victims needed to feel safe and supported and to recover from their trauma. So information about the system and what paths look like, what might happen to manage their expectations, clear information about decision-making timescales and to be kept informed during them, information about the outcomes of decisions, information about the types of interventions, sorry, that's repetition, and information that they needed to help them feel safe, that they needed a single point of contact to handhold them, to provide them with information and signpost them to the support at appropriate times, feeling that that they were offered information perhaps right at the start of the journey, but at that point they were too they were too involved in it. It was too new, too traumatic, and they needed to be offered information at a time when it was appropriate for them, whether they felt ready to accept it. And just finally, that the victims of children who'd harmed were open to ideas of restorative justice practices, but wanted reassurance that it would be done correctly. And I think that's it.